So, a long time ago, well, at least a couple of years ago, I was working for a law firm and became familiar, doing it many times, with arbitrating uninsured motorist and underinsured motorist claims. And it's something I learned about and have done for quite a number of years now. Done it well, done it efficiently, and enjoy the process. So what's different about the UM case versus a court case? Well, a UM case starts like any other with my client getting the medical treatment that they need, me being in communication with the insurance company, letting everyone know along the way where things stand, and then submitting all bills, records, lost wage information, other damages, photographs, everything. Everything goes into the insurance company, and then we try to work out a fair settlement. Sometimes we do, sometimes we don't. When we do, the case is wrapped up. My client will receive proceeds, money from the settlement, and that's the end of the case. On the other hand, if we are not able to reach a fair deal for my client, then arbitration demand is filed. Depending on who the insurance company is and what the insurance policy calls for, it can either be a 3-judge arbitration, where I, as the lawyer, appoint a judge, appoint an arbitrator to the case. The insurance company appoints their arbitrator, and those two get together and select a third neutral arbitrator. Or it may be, if the policy calls for it, submission to the American Arbitration Association. Now, this procedure, well, it can happen really in any case, but especially in the cases with what they call the substandard insurance carriers. And those are the ones that usually have state minimum limits of $25,000 per person, which is wholly inadequate. It's not enough in many, many cases. So arbitration is started, one procedure or the other, the 3-judge arbitration or the AAA arbitration. And then from there, both cases follow basically the same track. The written records are submitted to the appointed lawyer by the insurance company, and then there will be a sworn statement, which in a regular case is called a deposition. In a UM or UIM case, it's called the sworn statement because we're really out of court in a private setting. So the sworn statement goes ahead. These days, most of those are going by Zoom. And that's a great and efficient way to keep things moving faster than things are moving in the courthouse, by the way. So the sworn statement goes ahead. Sometimes a doctor's deposed. Sometimes the insurance company will hire someone to review bills or medical records or necessity of treatment. All kinds of objections that the insurance company may raise to a case, trying to hold down the eventual payment. That's their outlook, that's their job, and they love paying less than a case is really worth by presenting what they can to make that happen. But regardless, we move through the case, we move through it quickly, and then the case is set for a hearing. Again, these days, usually by Zoom. I've had dozens of cases, both as the lawyer on the case and as an appointed arbitrator for the claimant on cases. And these have proceeded by Zoom, and they've gone really well. They usually are a couple hours at the most, and then the judges get together, make their final decision, and have an answer that day or sometimes within a couple of days. That's it. So as I said in another video, the cases are moving really quickly in arbitration in the UM and UIM cases, especially compared to the courthouse, where there is a general delay and no jury trials going on at all at this point. So if you have questions about procedure, if you've been hurt in an accident, hit and run case, hit by someone without insurance, have questions about your case, even if it's proceeding with someone else, and you have questions on procedure, I'm always happy to answer your questions. Mike Mannis, 312-704-4300. And if you're an attorney, either with questions on or UIM procedure, I've done a lot of these, and I've helped a lot of people over the phone tell you what you need to do to keep the case moving. Please feel free to call me as well. And for that matter, I always appreciate being appointed as claimant's arbitrator and really becoming part of the team to keep your client's case moving, get you to hearing, get you to settlement, and get your case over with hopefully smiles all the way around. That's that. More questions, call me. Mike Mannis, 312-704-4300. Thank you.